Hi, Henry Haddad, immigration lawyer and business lawyer for over 34 years here in Los Angeles. I've helped many families from all over the world immigrate to the U.S., whether they came here initially as a student, whether they came to unite with their family members or came to operate a business. We'll always try to find ways to make that person a lawful permanent resident if they want to live in the United States. Today's topic is waiver. What is a waiver and when does it come into play? Typically, if you have a relative, and let's say for immigration purposes, there are two categories of relatives: immediate relatives and preferential relatives, if you will. Immediate relatives are husband or wife, U.S. citizen, children under 21 of U.S. citizens, or parents of U.S. citizens who are over 21. Those are the categories that fall under immediate relative. So let's say you're a U.S. citizen who wants to apply for their parent to become a U.S. resident, and you're over 21, except your parent entered the United States unlawfully without inspection. For that process to go forward, your parent would have to be interviewed in their home country as the application itself moves along, first with immigration and then goes to the State Department. The problem comes up is that you've acquired unlawful stay in the United States of over 1 year, and if you leave the United States, you're not eligible to return for 10 years. So many people don't do that because they've lived here all this time and they don't want to spend time outside the U.S. for 10 years. So this waiver program was initiated to relieve this burden on family and then this division of family. And here's how it works. The application process starts with immigration, and then it'll go to the National Visa Center, the State Department that handles visas. Once it goes to the National Visa Center, then you notify them, say, look, we want to file a waiver, and what this waiver does is it makes a person who has accumulated unlawful stay, who cannot return for 10 years, it waives that ineligibility. That's what it does. So when does a waiver come into play? Obviously, you have to have an immediate relative petition. Your husband or wife is applying for you. You're a parent of a U.S. citizen, child, and you're a child of a U.S. citizen parent. That's the starting process for the immediate relative petition. Then you look at the eligibility. Okay, someone applied for me. I'm an immediate relative. Who are the qualifying relatives upon which this waiver is based? It's a little bit different than the immediate relative. It doesn't have to be the same person, but most often it is. So the qualifying relative is a spouse, husband or wife of the U.S. citizen. He or she qualifies as a qualifying relative to allow you to file a waiver, and parents of U.S. citizens, or parents of the applicant, if you will. There are also qualifying relatives that allow you to file for a waiver. Up until this month, your qualifying relative, whether a spouse, husband or wife, or parent, had to be a U.S. citizen. Beginning August 29th, immigration expanded that to allow a qualifying relative to be a lawful permanent resident. So this is great news because it brings in a lot more people to unite the families that makes them eligible. Now, what is this qualifying relative of? It's not of the petitioner, it's not of the U.S. citizen, it's of the applicant. So, if you're a child applying for your parent, because you're a U.S. citizen, you're born here, and you want to give status to your parent, you meet this part of it. Now, your parent has to have a spouse, husband or wife, who's a citizen or resident, or a parent, their parent, your grandparents, who are either citizens or residents. And that applies to all these classifications. So if your parent does not have a husband or wife who's a U.S. citizen or a resident, or their parents who are citizens or residents, they don't have a qualifying relative, and they will not qualify for a waiver. But if they did, and a lot of people have that, then they're eligible to apply for a waiver. With all waivers, you have to show extreme hardship. In other words, you're not granted a waiver automatically. You have to show the hardship on your U.S. qualifying relative. How is your husband or wife going to be without your presence here in the United States? What hardship would they experience if you're not allowed to return? Because the theory is you're going to go to your home country, be interviewed, and you say, okay, I want to go back to the U.S. as a resident. They're going to say, well, yes, everything's fine, except you've been unlawful in the U.S., you can't come back for 10 years. So what kind of hardship does that create? And depending on whether or not the extreme hardship is something that immigration will approve, if it's approved and they give you the waiver, it's I-601 waiver, 601A. If they approve this waiver, then when you go for your interview, you know for sure you're going to return to the United States as a lawful resident, unless, of course, you're ineligible for other reasons, such as you have a criminal conviction, drug convictions. Ineligibility for those reasons are not covered here, but this is just a basic waiver format. And the good news is, as of August 29th of 2016, your qualifying relative can be a U.S. citizen or a lawful permanent resident. So take advantage of this. If you have an application that fits within the immediate relative petition and you have a qualifying relative, you should apply for a waiver. And of course, if you have any questions, always feel free to contact my office. Thank you.